Yes, welcome to the No Stay Project live from the fortified compound in Mesa, Arizona. Glad to be with you here in HD this time. Well, I can't get my hair to work just right, but I'm glad to be here. Got a lot of stuff to get to. I'll get to the call soon, but there's a couple of things that I have to address. But I do want to thank, of course, my gosh, Dan, for his continued support of the show. More than generous this time. Really appreciate that. Of course, Bill up in New Hampshire also. Appreciate the support, and everyone else who continues to support the show. If you'd like to be able to support the show, it's definitely appreciated and needed. Just go to markstevens.cells.com or markstevens.net, the website for the big show there. Wow, what do I get to first? I got I got an email about, somebody left a comment, and it's a typical, it's one of these people that claims to be really wealthy and they know the court system, blah, blah, blah. And they left a comment on the interview I did with the law professor. And, I've already addressed this particular kind of criticism, but what the hell? I'll take a few minutes to address this crap again. Since it comes up, and who knows, maybe you'll actually encounter one of these critics that will try to convince you that what I'm doing is wrong, that I'm just a simpleton from Long Island, just some schmuck from Long Island. I'm not a real lawyer. I'm an internet lawyer, even though I've never claimed to be a lawyer. I think what I do is honest. So I did address this before. And it has to do with the applicability of the Constitution laws. Now, it's been framed before as a way to make it look like I'm an idiot. And they try to, that's why, I have the acoustic screeching about philosophy, or the meme from Ancient Aliens where it's philosophy, and that is that the courts can't respond to philosophical questions or philosophical issues, and the applicability of the laws is a philosophical issue, and they can only handle legal issues. And so this critic is trying to go on a new spin on that same stupid argument, and I can't have a tech issue. I mean, someone's saying they can hear me just fine. So if somebody can't hear me, it can't be from my, it's not from my end over here. So the difference here, the different spin that this this fabulously wealthy and successful person would have us believe is that the applicability of the code is a political question. And political questions are for the legislature. They're not for the court, because the court can only handle legal questions. See, an example of that is whether you're being taxed and whether it's, it's appropriate to tax you is a legal question. The amount that they're taxing you is a political question that has to be resolved through the political process. Oh, sir, I know 99% of what is going to destroy your business. I can't help you there, because the amount that they're trying to tax you, that's a political question. So this person is trying to convince, I don't know, trying to convince you or unsuspecting people watching the videos that I am trying to take a political question into court, and the courts, they just don't have the jurisdiction to do that. So I'm trying to mislead everybody. Well, I'm going to cover this one again, and I'm sure it's going to come up. If we accept, for sake of argument, that these critics are correct, and there's two. It's not like there's a whole legion of people doing this. It's two people. If we accept, for sake of argument, that what they're saying is absolutely true, the applicability of the code is a philosophical question, or a political question, or a political philosophy question, and it is not within the realm of the courts to make decisions on and address, then the cops and the IRS and all that should not be permitted to argue that the laws apply, because arguing that the laws apply is a philosophical issue, or it's a political issue. See, they want to have their cake and eat it too. They want that the courts can accept in a positive sense that the laws apply, but they don't want to address whether the prosecution actually has any proof. So what they do is they dishonestly frame it as a political question. Well, again, if we accept it as true, then if I'm not allowed to challenge the assertion, then they're not allowed to make the assertion. You see how logic works? I went through this it was a real life scenario, not just with, some schmucks on the internet. There was Greg St. Ives was a hearing officer up in New Hampshire, and he said the issue of jurisdiction was not within the purview of the appeal process. Okay? And I said, well, then that kind of hamstrings you. You can't make a decision either way, because if you decide that they do have jurisdiction, you're violating what you just said. Jurisdiction's not within the purview of the hearing. So you can't make a decision either way. And he did it anyway. Well, Mr. Stevens, I understand your position, but I'm going to do it anyway. I'm going to decide this way anyway and contradict myself. So this is that's the part, when you try to inject some reason and logic into this, okay, and point out the inconsistencies here. So if Greg Ives had any intention of being honest, he would have said, well, gee, if jurisdiction is off the table because I just said that, then I can't decide that the New Hampshire state government had jurisdiction to do what they're doing. He didn't do that. He didn't do it. And so it's that's a real life example. That's something that actually happened. Of course, I wasn't able to release any of the video or audio, which would have been nice because there was some good stuff in here. I tell you right now, there was some good stuff like that where you can actually hear Greg Ives. Yeah, Greg Ives. I think it was either St. Ives or Ives. Ivy. Anyway, I guess you can look them up. Greg Ives or Greg St. Ives up in New Hampshire. But that's what he did. And this is what you can expect when you start talking with these people who are trying to make an argument work that these laws, these written instruments actually apply to people because they're magic. Well, Mark, they're not like they actually come out and say this. They're laws. They're not just written instruments. Well, I have a Supreme Court case, it's several. They're just written instruments. And you know what? I got my damn eyes. I don't need a lawyer, and none of us need a lawyer or some shill for the legal department, the legal system, some bureaucrat. We don't need people to tell us what our eyes can tell us. The Constitution is a written instrument. It started out as 4 pieces of paper. There are pictures of it online. So anyone who's going to try to say, well, it's more than just a written instrument, it's special. The burden is borne on them. They have the burden of proof. They have to prove that document applies. And it doesn't help you, and it doesn't stop the investigation, honest investigation anyway, to just turn around and say, dude, you're arguing philosophy. No, this is real life. We're talking about real written instruments that you can see, and people are making allegations that they not only apply to hundreds of millions of people, but they also create obligations. And you do not get excused from your burden of proof by saying, well, it's political and the courts can't address that. We're not in court right now. Even if we are, if someone is making a political claim in court, such as the laws apply to me, if the courts can't hear political issues, you see, logical, reasonable certainty and consistency, which is what you're not going to get with these critics. And what you're not going to get, where I have the tentative title of the show here, the big show today, Franchise Tax Board Agents Acting Badly. Boy, I tell you, Brad Cotino, who is counsel for the Franchise Tax Board. I believe he's up in Sacramento. I don't know for sure because they don't let, they don't always let you know, which is part of what, of them acting badly. We have a hearing coming up this month, at the end of the month in Los Angeles. And like I've mentioned before, I can't believe that we are before the Board of Tax Appeals. We have 3 administrative law judges that are going to hear this. So it's not the same as the Board of Equalization, which were 5. At least at one time, there were 5 of them that were elected. And 100% of the time with the Board of Equalization, which is why I haven't done one of these appeals in well over 7 or 8 years, because what they do to fix the game, and it is rigged, and it is my evidence, you will get the issues that are before the board, and and they'll give you the official pretrial or pre-hearing statement. Whatever issue is not listed on there, you cannot discuss, and they won't allow it. Okay? They don't, they're not going to hear it. How about phone call when it's not on? It's not an issue. The Board of Equalization, in my proof that it's a rigged game, okay, against us, is that 100% of the times they got the issue wrong. And no, it's not just a harmless mistake. Oh, Mark, you're right. No, it was Abba Fungul. You've got your 10 minutes, buddy. And it goes now. In fact, you've already lost a couple of minutes. That's what they did. So the last time I did this was in Culver City. 3 hours it took to get from San Bernardino. Okay. So I know of what I am speaking of. And yesterday, even though this administrative law judge was trying to say, well, we're not the Board of Equalization, it's a different agency, they did exactly the same thing. And so he said, well, Mark, your client's issue is, as I understand it, it's an issue of law. And that there's an issue with the word, with income. And I said, no objection, you got it wrong. So I was able to correct him. Our position is that the Franchise Tax Board made legal claims against my client. Upon questioning them on the evidence to support those claims, they got nothing. In fact, Mr. Coutinho agreed that the legal determination that formed the foundation of the assessment was an assumption. And that's why he got off the phone real fast and refused to answer whether his assumption was reasonable and rational to justify a presumption of correctness. So he doesn't want to change it. So what does that tell you? They will not even get, this is the thing. If my position was wrong, why can't they even get it right as to what the issue is before the hearing? Because again, I don't care what these keyboard warriors, Mark is an idiot. That's not what they do. That is exactly what they do. I've personally witnessed it. Just because they don't do it to everybody doesn't mean they didn't do it to me and the people I work with every single time. And it happened again yesterday. This guy actually had the nerve when I pointed out we had an issue of fact, not an issue of law, had the nerve to play stupid and ask me, how could that possibly hurt your client? I said, are you serious? I have to explain the differences in a burden of proof to you, the administrative law judge? Here you go. An issue of law, the burden is extremely high, and I can't defend against it. Got it? Whereas an issue of fact, I can defend against it. And it's a very low burden. I just have to I just have to prove that they're true. I have to prove that the facts as alleged are true. Do you get it now? When you make it an issue of law, I can't win. I have no defense when you make it an issue of law. I cannot win. It is a burden that even if I showed a legitimate court case with a contrary legal interpretation, okay, there is so much stacked against it. I have to not just prove that you are wrong in your legal interpretation. I have to prove that it's just so wrong it shocks the conscience. So it's a much higher legal standard, and it's not one I can meet. Do you get it now? How about it's grossly unfair to misstate what my position is and then force me to try to defend against the position I didn't take? You can't believe these people, and then you want to think that this is fair. The deck is stacked. It's a rigged game. And he says, well, this is an issue you can bring up and you can raise your objection at the day of the hearing. Why? Why do I have to wait till then to correct the record? We had nothing, no mention of the fact that we have dates and times of speaking with agents and we quote them. Doesn't matter. We have all those statements as evidence to prove that they don't have a leg to stand on, that they have no evidence of jurisdiction. He lies in a document, which is the problem using copy and paste there, tough guys. And so he lies, brazenly lies, that our issue is, appellant argues that there wasn't a report of income made. Wow. So I bring up, because Bradley is late to the pretrial hearing, pretrial conference. And I said, well, Mr. Coutinho lied. He deliberately misrepresented our position. Is he subject to any kind of sanctions or even correcting the record, even like making him withdraw the statement and accurately just, address our actual position? He said, no, my hands are tied. You'll have to take that to the Superior Court. I said, he can lie and misrepresent someone's position, and there's nothing. You can't even strike it from you can't even strike a brief from the record as misleading. Really? I said, what if I started lying right now about Mr. Coutinho? You're telling me you just have to let me spew my lies? There's nothing that you or Brad can do about it? Nothing? You see, we, in their eyes, are just idiots. This is just going through the motion. They have no intention of actually being fair. If they did, if someone lies in a brief, and I mean lies, they would at least strike it. But the Franchise Tax Board and the Board of Tax Appeals in California, like everywhere else, are bedmates. There's no way that he is going to rule against the Franchise Tax Board. That's not what they do. At least with the Board of Equalization, there were sort of independent people that could that would take a vote. I've actually had people vote in my favor before. Oh, it gets worse. It gets worse. Bradley now decides he's going to contest all the facts, including statements that he made. Okay? See, honestly, I accused them right out in the open like that with no, I mean, I was very blunt about it. Called them liars, dishonest crooks. They said nothing in their own defense. And why? Well, because they don't have to, because the administrative law judges got their back. See, what you're seeing happen in the White House happens all over the place. They can say literally whatever they want. And the courts, yep, you got it. Yeah. Okay, they're arguing that there was no report of income, and I'm seeing a report of income. So yeah, Brad's right. So even though he is disputing all the facts, like a typical scumbag the defense counsel for a tax agency, he is, I said, well, I'm going to need on the record right now the names, the full names and contact information for each one of the agents listed in my brief, and the contact information, so that we can have subpoenas issued. And Brad said, "Aba fongul." He said, no. So this is an idea, so you can see just how unfair these processes are. He actually said to me, well, Mr. Stevens, I don't see how that is Mr. Coutinho's burden. That's your burden. I said, excuse me, they don't give last names. If that's my burden, how do you expect me to go about doing that and getting their last names when the agents won't disclose that? I said, it's like the IRS. I said, you crooks use pseudonyms so that you, with the express purpose of defeating process. So the IRS can honestly say to a process server, an officer of the court, we don't have Avelia Calvin working here. So we actually had a process services. We've got a legal document with Velia Calvin's name on it. It came from this address. Do we have to get the Postmaster General involved that we've got false documents going through the mail? Of course, they called our bluff, and we couldn't get process on them. So I voiced my objection. But what's going to happen to this? This is how grossly dishonest bureaucrats are, government agents, whatever the hell we're calling them. What's happening in the White House is just making front page news every day. What's happening in Sacramento doesn't get on the news. No one's going to put Brad Catino's face, if that's his real name, they're not going to put his face on the front page news and say that not only does he dispute all the facts, he's not going to give through a discoverable. It's discovery, you dickhead. They didn't teach you that in law school either. That's discoverable material. They have to provide that before the hearing. How can we meet our burden without having the witnesses? Well, Mr. Stevens, I don't understand. It looks like it's your burden to get that contact information. How? It's secretive. The hell's wrong with you people? Because just like this critic who thinks the applicability of the law when it's actually an accusation in court is political, okay? It's any excuse to make the system look good. It's just shilling for a group of men and women who can't or are unwilling to provide the services to the community on a voluntary basis. No, they have to use a prison system. And so you get these critics out there with these stupid comments. Well, it's philosophical. Yeah? Well, if they're making a philosophical argument in court, guess what? The court can't determine that the code does apply because that's a matter of philosophy or it's a political question, so it's not permitted. Yeah, obstruction of justice, man. I tell you, it's definitely conspiracy to definitely hurt people. So now we've got a administrative law judge who is conspiring directly on the phone with the Franchise Tax Board to obstruct justice. Just on the issue of that it's discoverable material to have the contact information of a tax agent. Can you imagine if it was a traffic situation and the police officer didn't identify himself? And the prosecutor saying, hey, man, not my burden. He's only my entire case is based on his testimony, but it's not my burden to find out who he is and his contact information, give it to you. Again, to quote from my cousin Vinny, it's called disclosure, you dickhead. The idea that the very witnesses that the Franchise Tax Board relies on, because this is one of the things I got into because I made an objection to documents being put in. I said, does relevance actually count in this proceeding? He says, yes, Mr. Stevens, of course, relevance. Then what possible relevance can any of his documents have to proving the foundation of their case that the Constitution and laws apply? Are you telling me that a report of income, which is compulsory on a threat of jail, you tell me that proves the Constitution applies or has any way of proving the Constitution applies? We've already been through this. He says it's an assumption. He can't prove it. He can't prove relevance. So that I'll let everybody know. I'll report on what happens. We're going to put in for the subpoenas. I sincerely doubt they're going to grant them. They've been denied 100% of the time. Okay, so the equivalent of this is we're going to a hearing, and the cop who wrote the tickets, the one who did the stop, is not going to be there. They're not going to call them. And it's not going to make a difference in the world to those 3 administrative law judges who are just there as rubber stamps. Franchise Tax Board is correct. Franchise Tax Board is correct. Please do not investigate me. Or to borrow a phrase, my finances are a red line. Yeah. So don't anyone kid you. Look at the issue critically. Get more content. Question. Somebody ever says it's a philosophical issue, then you fire back. Well, isn't it then philosophical when they allege the laws do apply in court? Nah. You got to do better than that. That is just garbage. And again, that's why these stupid arguments are limited in their appearance to just Facebook or YouTube, because they're not seriously argued. I've never had a prosecutor come out and say, "You're arguing philosophy there, man, and that's not allowed in court." No. At least they got the guts to just come out and say, "How about Fungul? I don't have to prove that. And I got a literal army to back me up, bitch. I ain't got to prove a damn thing to you." But these internet keyboard warriors, philosophy. Did you hear the Chief Justice of the Arizona Supreme Court and say, "Well, Mr. Stevens, you're actually asking a philosophical question, and that's not something the courts can answer"? No, he at least tried to do something. So don't take these criticisms for what they are. And understand that all they're doing is basically shilling for a bunch of criminals. I had to explain to an administrative law judge what the difference is to my position as whether if I have an issue of fact as opposed to an issue of law. I really have to explain that? Oy vey, these people. Why do they do it? Because they can. Just be wary when you've got these criminals doing this to people, bombing buses of children in Yemen, and yet their criticism is leveled at someone doing a little small, tiny broadcast here. Tells you something. Again, I'm not backing away from the criticism, and I'm not banning or blocking anybody. I've got no problem with the criticism. That's why I addressed it. But man, if you're going to do some criticism, get it right. All right, let's get to the calls over here. We got, I think, a new caller. We got area code 209. You're live on the No State Project. What's your name? Where you calling from?
Donna from California.
Oh, hold on there. I'm sorry, was that Donna?
Yeah, Donna from California that had like a mini train wreck at the arraignment.
Oh, yeah. Do you have any better news for us today, Donna?
Well, I sent you the recording of the whole thing, and I was wondering what time you got after the show to let me know if I can fix it or not, because I'm going back.
Well, you got to give me the cliffs. I get a lot of video and audio every day, and I wouldn't be able to get anything done if I was addressing all that. So you're going to have to give me the cliff notes and let me know what happened, and we could take it from there.
So which email do you want me to send you that? Because I sent it to your regular email.
Yeah, I'm vaguely remember getting that, and I got a few just today as far as audio of things that have happened this week. And again, it's difficult for me to get to everybody. So if I'm not directly doing consultation and working with someone directly, like with the franchise tax board thing yesterday, then I may not be able to get to it. So there's kind of a priority there. But if you just give me the cliff notes on what happened, then I can give you my my opinion.
Okay.
So what happened?
She accused, or she made a claim that she had jurisdiction, subject matter jurisdiction, because I was saying to her there's no subject matter jurisdiction, but what ended up happening is I had stated court rules and the 1004.4 to her that the court and Rachel Butler, the cop that stopped me, violated not opposing the demur. and violated putting in the demur on the calendar before the arraignment date. And I was thinking that the administrative officer, aka commissioner, was supposed to look to see if there was any evidence filed, and there was none, and the cop had 15 days to respond to the demur once it was filed, and she didn't do that. So I'm thinking, why would the commissioner say what she said and dismiss the demur and just go on without any evidence? And I told her, you can't argue without evidence.
Well, we don't want to necessarily make statements, so we should always frame it in as that the prosecution hasn't submitted the evidence.
I asked her, can I come in and make a claim against anybody without any evidence? And she didn't. She ignored me twice.
Yeah, well, they're going to do that because it would be exposing the double standard because they're allowing a police officer to do that. And some will, so did they overrule the demur?
Yeah.
Okay. Did they give you any grounds? Did they give you any explanation why?
Well, that's why I wanted you to listen to the 17-minute video.
Oh gosh, 17 minutes. Yeah, that's not something I'm going to be able to get to today. That's why it really helps to give me cliff notes. And if somebody watches a video and gives me a timestamp for when certain things are said in the video, so I don't, I can save some time, that really does help. It's just, time is not something that I have a lot of. So that's why I urge people to do that, especially if you're able to send me a YouTube video. It's easy to just put the times in there under the show notes, and you could just jump to those times, which is probably something I should do when I do the Saturday show if I don't pull the video down, so you can just go, over the commercials. But did they at any time did they explain that the facts as alleged did prove that the Constitution applied?
No.
Yeah. Well, what you can do is you can file a motion to reconsider that, and that's without hearing this, because the only legitimate way to overcome or to overrule the demur is to show on the record the facts that the facts are sufficient to set forth a public offense. It is not sufficient to just show facts that show an alleged violation. You have to show that the code applies and was violated. So there isn't a public offense if there's no evidence the code applies. And anybody wants to argue that, 218-632-9399. Passcode is 2020. Damn, I would love to hear that argument, because I've had experienced prosecutors just not able to explain exactly how you prove the code applies by proving it was violated. So you can contact me after the show, and I can get you the template for the motion to reconsider the demur.
Okay, and then she just dismissed the judicial notice without any reason, and then she said
Wow.
that I had to subpoena the discovery and Brady request, and I don't know what.
Let me just take a second here for those who may not be aware of just how dishonest the blanket denial of the motion for judicial notice is. Under Section 451, I believe it is, of the Evidence Code in California, it's different with the judicial notice in California as opposed to at the federal level, because at the state level in California, if you provide them with the proof of a particular statute or part of the Constitution, they are obligated to take judicial notice of that. So you give them the ruling. Let's say it's the Duke-Majan case, where there is a narrow exception to the Anti-Injunctive Tax Act of Article 13, Section 32 of the California Constitution. And you give them the Duke-Majan case, and it's mandatory. They have to take judicial notice of the exception. Okay. Here, what I have in the motion for judicial notice is we want them to take judicial notice that the California court system is adversarial, just like all the other court systems in the United States. And then this judge denied that. That's how dishonest That's how dishonest these people are. It's not this is evidence. You are reporting to me something that has happened many times. I do that for a reason. It's so that you can now have better grounds to disqualify the judge if that's what you want to do. In your motion to disqualify the judge, you can say you're very fearful doing anything in front of this lawyer because they're denying it's an adversarial proceeding, when everybody who's ever taken any kind of civics class in the United States knows that it's advertised as an adversarial system. So there's your they are so biased against you that a basic common truth of the American legal system, they go abba fungal.
Yeah, I read somewhere where all traffic is administrative.
No, they may be done by a commissioner, but you know, look, even if it is considered administrative, then you'd have to appeal to get a judicial proceeding. It doesn't change the due process requirements necessarily, and it doesn't change that they have to be fair. It doesn't change that there is Brady material that is necessary. And you do not, and this is another thing, maybe add to the list of judicial lies. This judge, and this is for you and anybody else, any judge that tells you you have to subpoena discovery is wrong. The only time you have to go and do any kind of motion to compel is if the prosecution is not giving the material timely. Okay. And then you can do a motion to compel. I prefer just to do a motion to dismiss for prosecutorial misconduct. I don't want the judge to.
If I served the prosecutor and I said there is no prosecutor, I said I served the cop and I served the court, or filed and date stamped in the court for on the record. And she said that so you didn't give this to the prosecutor. I says, no, ma'am. I says, he wasn't there at the time of the stop. He has no firsthand knowledge.
Oh, what are you're killing me here, Donna. If there's a process, I say right in the instructions, if there is a prosecutor assigned, under no circumstances have communication with the police officer. I'm very clear about that. You should be mailing.
In the court, when you go look up your case, they're listed for prosecutors.
Let me say again, if you have to give a copy, it still doesn't mean that there's a subpoena is necessary. You still just have to give a copy of the discovery request to the prosecutor, but never communicate with the police officer again outside of court. In fact, the only communication you should have with the police officer is if he's on the stand.
I just mailed it. That's all I did.
Okay. Well, from now on, we got to mail a copy to the prosecutor of everything that you file, and nothing goes to the police officer. Even mailing it to the police officer while there is a prosecutor could get you in trouble for witness tampering. I know it's not, but they could use that against you.
But I asked, and I even looked at the court, and there's no prosecutor listed.
Okay, that's different. I was under the impression that there was a prosecutor, but just because they weren't there that day. And okay, all right. If there's okay, then you're okay. As long as so the police officer is acting as prosecutor until counsel is puts in a notice of appearance, and until such time the police officer is on the hook for the discovery. So as long as you got to copy that to them, then you're good to go.
Yeah. She's the only one liable so far when I look at the case in the court case lookup.
Got it. All right. Then you're good to go. Then there's no issue. So, but for those.
But why is woman asking me? So you didn't send one to the prosecutor? Well, I said there is none.
Right. And in a minor traffic like this, they should know better.
Well, yeah, there is none. It's just this is an infraction. And then first she says, in the recording, it's a civil, and then she changes it to criminal, and then she doesn't even know what it is. She's using both at the same time.
It's it goes to like when we asked them if it's a civil or criminal proceeding, and they don't want to tell you. Oh, it's an infraction. Okay, does it fall under civil or criminal? Which one is it? That's why I tell people when they play that game, ask them what the burden of proof is, and when they say it's beyond a reasonable doubt, say, well, why didn't you just say criminal? Why did you have to play a game with me? But that's how we end that infraction game, as I like to do in California. What is the burden of proof? Beyond a reasonable doubt or preponderance of evidence? Whatever they say settles it. Preponderance of evidence is civil. Beyond a reasonable doubt is criminal. That's the only two that you got there as far as trial levels go. I'm running out of time here, so get with me off air. I'll send you the motion to reconsider the denial or the overruling of the demur, and we'll take it from there.
So there's no way to send an affidavit of fact rebutting any of her claims against me in this recording.
If you want to do that, you can, but that, again, it's up to you if you want. If you will be subject to cross-examination if you do that.
So all I know is okay.
Well, look, I'll discuss it. We can do on email, but I'm pretty low on time. I want to get one last call.
Okay, so you just want me to email you?
Yeah, and give me a reminder. I'll send you the template for the motion to reconsider.
All right, thank you.
Appreciate the call. Donna in California. Has anyone seen a verbal armament? Has anyone seen any evidence from any of these people that say stay at home and read your Bible instead of showing up in court? Have any success exposing the crimes committed against them yet? My gosh. Let me give some sound legal advice here, everybody. You just make critics' heads explode. For heaven, please do yourself a favor. Don't blow off court dates. I rarely give legal advice, but here I have no problem putting my butt on the line, so to speak, and giving legal advice. Make all your court dates timely. Please do not blow off a court date. It's just going to escalate. It's going to get worse. The idea. Do people really say that? Stay at home and read your Bible instead of showing up at court? That is, I don't have the time to get into that. But we've got, he's been on the show maybe before. Maybe we've got some good news. We got Malach from Chicago. Welcome back, my friend.
Thank you. Appreciate it. Yeah, we're, I can't call it good news yet, but I'll definitely call it on the path to good news.
Okay.
And at the end of this, I'll explain why. But I had a arraignment yesterday, and to put it into perspective, that was my fifth time appearing, or I shouldn't say appearing, but my fifth time taking a stroll on out to the district court, which is about 30 minutes from me.
Damn.
Yeah. So, and sometimes I have to come from work, which is additional 30. So, okay. But anyway, so the last appearance before this scheduled arraignment, and I'll put that in quotations, was for a motion to dismiss for prosecutorial misconduct. The judge, also basically acting as the prosecutor in this case, denied that motion, stating that evidence is a trial issue and that the prosecution is not required to present evidence until trial. So fast forward to yesterday at arraignment, the judge said the exact same thing when he first asked, how are you going to plea? And I said, objection. Are you satisfied that the prosecution has met their prima facie burden? And he said, they've submitted. Well, he said, well, he turns to the prosecution and asks, oh, have you've submitted Brady? Have you not? You submitted the reports and all this and that. And so, up until this point, the past couple of times I've gone in, I've asked the question about evidence specifically, and what has the prosecution presented the evidence to rebut on motion? Has that prosecution presented the evidence to support their claim, etc. And this time, what I decided to do, and I remember before going in, was why don't we ask about the witness as well? So instead of just focusing on the evidence, the question I asked was, I still haven't seen any evidence, of any witness having firsthand knowledge to support and prove the prosecution's claim that the laws and constitutions apply. And the judge kind of got a little quiet, and he tried to move on. He said basically what he said is like, I need to enter a plea without saying this, but he was saying basically I need to move this case along, and then to paraphrase or to what he was really saying was basically, I need to enter a plea on behalf of the prosecution because obviously you're not going to plea and blah, 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 blah. So he did that. But here's and I know we're running out of time, but here's where I think the beginning of the success story is. And I think part of this is because I'm not going to say definitely not an expert in procedure and legal matters, but I've definitely done my homework over the past year or two, and I've been able to learn how proper procedure. And so I think I know that when I've been in court with various judges, I've been able to build some rapport, and they've been able to see my points. And while they're not able to be completely fair, in my experience, a couple of judges have been about as fair as they can be given the circumstances and given the fraud. And so this is where the success story is starting for me is the judge. So he entered a plea on behalf of the prosecution, obviously over my objection, but he set the trial date for September 16th. And so this matter happened in the first day of the year, January 1st. The first appearance was February 4th. And our speedy trial date starts, I believe that's the first appearance.
No, speedy trial starts the day they file the complaint. That's generally the way it is. So if you're saying it was back in September, you got a pretty
back in January.
Oh,
back in January.
January 16th. Oh.
But he set the trial date for September 16th of 2019.
I got it. I screwed that up.
5 months.
I see.
That's okay. Yeah, so he set it for 5 months from now. And he set a preliminary just kind of status hearing on July 8th, I believe, to see if there's been some sort of deal working out.
Okay, well, wow.
Go ahead.
I'm just, after what I went through with that administrative law judge yesterday, the garbage that was spewing out of his mouth, to hear now, you really did a good job on nailing the issue of the witness with firsthand knowledge. But what I really don't like to see, and I know it's something that's parroted a lot by these 2 or 3 critics, that the prosecution is not required to present evidence till trial. Now, that statement on its own is true. But in this context, he's trying to mislead you. And he's trying to mislead. It's a misleading statement. So it's just like when they say that jurisdiction's a trial issue. It's a true statement. But it's extremely misleading because when you're at arraignment and you're challenging jurisdiction, they have to establish that. And the thing is, I'm not necessarily asking them to present evidence to prove something beyond a reasonable doubt now, but I want you to at least, let's examine, like you mentioned, like you said to him, we need to know what he has. This isn't a murder trial where they need to lay out hundreds of pieces of evidence. We're talking about a code violation. Where is the evidence that he plans to use? Just what is it? What is the prima facie evidence necessary to move this forward? And to turn around and say he's not required. So what we should say is, well, objection. Are you saying that the record is devoid of any evidence to establish personal and subject matter jurisdiction? That.
So are you saying So you're saying if you say objection, are you saying that the record is devoid of any evidence of in personam or subject matter jurisdiction?
Yeah. Now somebody did this in Ohio, and I have the transcript on the website and in one of the videos. The judge, when they said, "Is there any evidence to set forth the prima facie case of subject matter and personam jurisdiction?" And the judge says, "That's what we're here at trial to determine." You just admitted to forcing someone to trial where there was no evidence of jurisdiction. And so here, I think is the same thing. And so because he's trying to mislead, yes, we want to call him on that. So you're saying that the prosecution hasn't met their prima facie burden to even have an arraignment.
Oh, I see. Because he said he doesn't need it till trial. I see. Okay.
Call him on that. Right. Yeah, we're calling him on that misleading statement. Just like when I say jurisdiction's a trial issue. Really. And so if I sued you, a judge and the prosecutor, you have to wait to trial to argue sovereign immunity? Really? Hey, I don't have to present any evidence till trial, remember?
Right.
Oh, sovereign immunity,
right.
that's
So,
a political issue, not legal. Can't raise it. Political. I'm sorry.
no, you're fine. And there's two little things that happened while I was in court that kind of even more so get me to believe that the judge was purposeful in his setting the date. One was the actual case before mine. He mentioned because there's actual prisoners that they brought up, and the prisoner had two cases. He had a counsel for one, and he had one a felony that he did not have any representation on. And the judge asked, "Do you need some time?" And he basically said, "Okay, well, if I grant you this continuance, then your speedy day trial, which is 120 days, is effectively going to be shifted to 150, etc." So that was coincidence number one. So at that point, and then number two, while I was up and talking to the judge, he alluded several times when I was talking about, okay, well now you've entered the plea, and now we're talking about the next time you come here in September. And I was asking questions. Okay, well, when will we select jurors? And he would, and a couple times he said, well, if the trial is necessary, and if you haven't already made a deal with the prosecutor, then yes, that will be the day we do this. And so when I got home, I was like, wow.
Well,
that makes a lot of sense.
Well, no, he's right. You got to, that's the way the process works, and that's. I'm glad he put it in those terms. I'll end with this because I got to go here in a few minutes, but I'm really glad you called. You gotta, if this is still on the docket and you meet with that prosecutor on July 8th, you can really give him hell. Because that's where he's supposed to put it on the table. None of this crap. I don't have to. You have to disclose. Again, it's called disclosure, you dickhead. From My Cousin Vinny. I love that line because it's always so appropriate in these cases, right? He's got to put it on the table. This is, and so proof that he has a witness with personal knowledge that the laws apply and you violated it, he's got to put up. And you write his stupid responses down and use it against him. Because what you should be doing in your head is, because we know that, how they don't like to throw these things out. You have to be building a case against them for prosecutorial misconduct. And so you're going face to face with this guy, write it down. Like what we did and when we got the dismissal up in Concord, Massachusetts. It was a wicked, awesome dismissal, Tiffany Castillo actually said she did not have to prove that. So you write it down and you get the date and time when they said it and you use it against them. They're going to deny they said it, sure, but you just go back to first base. Oh, so you do have to prove it. So what evidence do you have?
Right.
So we'll do the role playing after Saturday shows, and so you've got plenty. You've got a lot of time here to prep. This prosecutor should be wanting to make a beeline for that door after just a couple of minutes. You just zero in on his claim that the laws apply and you violated it. You want the proof that the laws apply, and you want the proof of personal firsthand knowledge of the witness they're planning on bringing against you. And we'll see. And you report to me because I know you will. It was great information today. If they turn around and say, well, you're making a political argument and the court can't even hear that, you let me know if the prosecutor is as smart as this critic or this other critic, this lawyer. So let me know if they're as smart as them, if they're brilliant enough to actually argue that you're making a philosophical argument and the court can't hear that.
Yeah, well, heretofore he hasn't said anything like that. So he's really been more silent. It's been, like I said, it's been me and the judge building a nice little relationship.
Sure.
For lack of a better word.
The prosecutor is not going to say any more than he needs to. Like when I did this yesterday, I'm directly accusing Brad Catino and his conspirator. I'm directly challenging them and calling them crooks and liars. And somebody could say that that's unprofessional. And no, I disagree. When you got the goods on somebody and they're trying to put it over on you and they're lying directly there and they're deliberately making things more difficult and throwing up a roadblock so you cannot have a fair hearing, yeah, call it what it is. they are lying. And I can't stand that you've got reporters and people who don't like saying the word lie. You know, well, it's a misleading or it's a mischaracterization. No, it's a lie. Just call it what it is. They're lying. And I don't think it's unprofessional when you have the goods. So, hey, I appreciate the call. Oh, sorry.
I was gonna say one other thing that, and then I'll let you go, that I think kind of spooked the judge a little bit, or at least got him thinking, was right before he was getting ready to put in the plea for the prosecution. I was like, well, he's asking me, what do you want to plea? And I was like, well, here for it, I don't see any evidence here. I don't think it's possible for me to plead with, all the facts of, the report of court or lack thereof. And I was like, but if you want to, take up the burden for the prosecution, I won't stop you. I'll definitely object. And then he's like, well, I will not be taking up any burden. He made sure. He's like, well, I will certainly won't be taking up any burdens for the prosecution. And I said, well, okay. Well, that's good to know.
All right, real quick, and I'll let you go on this. We don't want to do that. We don't want to give them any impression that we're refusing to plead. We want, hey, I'm intending on pleading guilty here, jerky. If the prosecution has facts to meet their prima facie burden, I'll rock and roll and enter a plea right now, guilty. That's what you want to do instead of doing that. Keep the focus on the prosecutor's burden of proof, all right?
Makes sense. All right, Mark, well, I appreciate it.
Hey, I appreciate the call. We'll talk to you soon. Oh, I didn't mean to do that, but we have Malach there, but we have to drop all that. But it's all recorded anyway, and it's up at markstevens.net. And here on my YouTube channel, No State Project. So I think we covered some pretty good ground. Really good call with Blake. And these lies, you have to accept. You have to, as your tactic when you're defending yourself against these crooks, and they are crooks. Why? Because they're men and women, and they force perfect strangers to give them money. Okay, threats on using a prison system that makes you a criminal. You have to assume that they're lying as part of a valid or effective defense. Don't take anything they say as true. If they say, "Hey, dude, it's 3:00. You got to go get some independent verification. Get your phone or something and verify the time," because it's only going to be to our detriment if we take a bureaucrat or a politician's word for something. Especially when you are in court, that prosecutor will say and do whatever or not say anything, whatever they have to do to get a conviction. And when they have a servile, dishonest administrative law judge or commissioner or justice, as long as that judge is going to carry the water for them, they will do whatever they have to do to get a conviction. And they'll just stand there mute because the judge will pick up the burden for them. There's somebody here, the big black, you're making me have to moderate this damn thing because of your username, and people who quote you, I have to keep, it's a valid, thing post there, but I have to keep doing that because of the username. You really should rethink that, at least for me, so I don't have to moderate the damn thing as much, because otherwise I just have to let it go. But again, remember the basics here, guys. We're sticking to keeping the burden of proof on them, and we're using logic and reason. So when someone turns around and says, "I'm stupid," or "You're stupid," or you just don't understand law because you didn't go to law school. You're not in court all day. You didn't take the time to do it like a normal person. And so you lack the understanding. So when you go into court and you challenge the application of the law, you're making a political argument. So never mind that you're just asking a damn question, because now a question is an argument. But the fact is, that's not what we're doing. It's not. When they make a claim in court, however you want to couch it, however you want to frame it, if the claim is made in court, philosophical, religious, whatever they call it, they have to have proof. And these excuses are trying to just discourage you and try to distract you from what's important. And what's important is that their claim has no merit. That's why they start arguing. Instead of just proving the claim is true, they have all philosophy. It's no different than these IRS agents screaming frivolous. That's how you would just ignore it by screaming frivolous 1,000 times. I actually have a 30-page brief or motion filed by an assistant U.S. attorney in Washington, D.C. And in 30 pages, they use the word frivolous 185 times. 185 times in 30 pages. Okay, and that 30 pages includes the table of contents and the caption page. 185 times. Yep. I'll just keep saying it enough. Anyway, I appreciate everyone tuning in today. Numbers a little, what do you do? But thanks to Dan, especially Dan and Bill in New Hampshire for the continued support of the show. If you'd like to continue supporting the show, it's really appreciated. markstevens.sales.com and markstevens.net is my website. So I probably won't be live on Saturday. I'll do what I can to get a pre-record. But hey, until we're live again, salud.